नमस्कार। देश की सर्वोच्च पंचायत में लोकहित की चर्चाओं से संबंधित कार्यक्रम संसद संवाद में आप सभी का स्वागत है। मैं हूं प्रीति सिंह। निगमित दिवाला समाधान प्रक्रिया को समयबद्ध ढंग से पूरा करने और शेयर धारकों के हितों के बारे में अधिक स्पष्टता लाने के उद्देश्य से इंसॉल्वेंसी एंड बैंक्रप्सी कोड संशोधन विधेयक 2019 यानी आईबीसी संशोधन विधेयक 2019 संसद के बजट सत्र में राज्यसभा में पारित कर दिया गया। संशोधन से दिवाला हो चुकी कंपनियों के मामले 330 दिनों में निपटाना होगा। आइए देखते हैं राज्यसभा में आईबीसी संशोधन विधेयक पर हुई चर्चा के प्रमुख अंश।
श्री मनीष गुप्ता जी।
This law has been enacted to resolve NPAs. The total NPAs today in the country is 10 lakh crore as stated by the government. But so the ground reality is that more than 3 to 4.5 lakh crores have not been declared by the banks as NPAs. And it seems that the general business community is of the view that there are thousands of such cases which can become NPA. So this legislation has only taken care of a part of the problem, like the tip of the iceberg. So that is why a more comprehensive law would have been useful. Sir, when the NABARD Act was amended in 2017, a section was inserted there for MSMEs, for special status for MSMEs, so that banks could be refinanced by NABARD when they loan to MSMEs. Even at that time, it was an inadequate provision. I am surprised to see that in this code also a certain concession has been given to MSMEs, but the entire problem which the MSMEs face and will face if this code is used against corporate debtors, it will affect them adversely. So the MSMEs provision in this act needs to be amended. The process which is followed in the NCLT, we find that the courts are giving much more time. And bank chairpersons of PSUs, they have become new power centers. So this is like a crony capitalism. This code has enabled this kind of a situation to develop. If it becomes more broad-based, the entire purpose of the code will be defeated. There's a 60-day limit. We have seen an additional time frame. So this is not required. We feel this should be dispensed with. The 60-day additional time frame only delays the process. And the main issue is infrastructure. Infrastructure constraints have not assisted the court. The 330-day limit, apart from the inherent power of the court, we cannot wish away the courts. There's Article 226. Apart from that, courts have an inherent power. So this 330-day limit itself is not getting this resolution process anywhere. The government needs to take a fresh look at this as to how to maintain the integrity of the court, as well as to see that this process has some impact on the economy. And so one of the main issues in this code, we need not only to look at infrastructure, we need to look at the bandwidth of the legal system. Otherwise, the resolution professionals, quality of resolution professionals is very important. It's not specified in the code. Who decides who is a good professional? Who decides the quality of the professionals? So there's a dearth of this. There's a lack of application on this. And sir, most importantly, in advanced countries, they have a mechanism by which they attend to corporate debts before the resolution process, so that they don't have to go into the IBC. We don't have any such mechanism in this country, and I would beseech the minister to kindly look into this issue.
श्री रवि प्रकाश शर्मा जी।
आज जिस दौर से गुजर रहे हैं, अर्थव्यवस्था जिस दौर से गुजर रही है, उसे बाहर लाने के लिए इंसॉल्वेंसी कानून में अमेंडमेंट लाया गया है। लेकिन जितनी बड़ी तादाद में मामले एनसीएलटी की कोर्ट में आ रहे हैं, सर, ना तो जजेस हैं, ना ट्रेंड इंसॉल्वेंसी प्रोफेशनल्स हैं, ना एजेंसियां हैं जो विशेषज्ञता हासिल रखती हैं। और सर, मेरे पास कुछ सूचनाएं हैं कि वहाँ पर इतने बड़े पैमाने पर बंगलिंग है। मुझे एक वकील साहब बता रहे थे कि एक वकील साहब जो प्रोफेशनल थे, नेगोशिएट करा रहे थे, उसमें उन्होंने काम रोक दिया। तो जज ने पूछा, भाई काम क्यों रोक दिया आपने? बोली मेरी पेमेंट नहीं करी गई अभी तक। बोली पेमेंट कितनी है? पेमेंट 1 करोड़ रुपया है। बोले तुम दवा होगी, खुद मरी मर जाओ। भाई जो बिजनेस है जिसको डिसॉल्व किया जा रहा है, अगर 1 करोड़ रुपया आप ले लेंगे तो बाकी लोगों को क्या मिलेगा? ये चीज चल रही है वहां। आप समीक्षा कराइए कि जितना हेल्दी एटमॉस्फेयर वहां होना चाहिए था, जिस पर लोग ट्रस्ट कर पाते, पूरे देश का बिजनेसमैन, बाकी सब लोग इकोनॉमिस्ट ट्रस्ट कर पाते कि नहीं चलेगा, सब ठीक होगा। और जो जल्दी वाला इश्यू है, टाइम कंस्टेंट है, वो डिस्ट्रेस सेल के लिए बहुत बढ़िया मैकेनिज्म है। सर, हो सकता है कि कुछ बड़ी बड़ी कंपनियों को रिजोल्यूशन प्रोसेस के माध्यम से जो स्ट्रेस एसेट्स है उनको अनलॉक किया गया, लेकिन मुझे पता लगा था कि 1 लाख करोड़ रुपए की स्टील कंपनी थी और उसमें 94% हेयर कट हुआ। किसका क्या? और ये जो कंसोर्टियम बने हुए हैं, जो शिकारी जो ढूंढ रहे हैं कहां पर इस टाइप की कंपनियां मिले हमको, और सिंडिकेट हैं। ऐसा नहीं है कि सिंडिकेट नहीं है। जो लोग बड़े बड़े फाइनेंशियल हब हैं, उन्हीं के साथ में काम करने वाले लोग हैं, जो प्रोफेशनल्स हैं, वो हर चीज को मैनेज कर देते हैं। तो मरने में फायदा है कि इलाज कराने में, अब ये सोचना पड़ रहा। सर, जैसा कि अभी जिक्र आया, इंफ्रास्ट्रक्चर की बड़ी शॉर्टेज है। बहुत सारे केसेस लगातार आ रहे हैं। आपने प्रावधान किया है कि थोड़ा टाइम बढ़ाएंगे, और वो आप देखिएगा 180 दिन में भी नहीं हो पाए थे, 270 दिन में भी नहीं हो पाए थे, और 330 दिन में भी नहीं हो पाएंगे। इतना स्लगिश प्रोसेस है, उसमें कमिटमेंट की कमी है, और उसमें वैलिड इंटरेस्ट है अलग अलग से। और अगर डिस्पोजल नहीं होगा समय रहते, तो आपकी समस्याओं का समाधान भी नहीं होगा। 1,03,000 करोड़ रुपया का बैंकों ने जो डिस्ट्रेस कंपनियां थी, जो उनके बिजनेस थे, वो मार्केट में रखे थे, तो उसका रियलाइजेशन हुआ है लगभग 40-42% के आसपास। तो ये बहुत आशाजनक और अनुकरणीय उदाहरण नहीं है। अगर इसी तरीके से पूंजियां बर्बाद होनी है, तो बहुत से दूसरे रास्ते भी हैं। लेकिन जिस चीज को हम समाधान बनाने जा रहे हैं, वो चीज ही मर्ज बनती चली जा रही है। आपको इस बात पर गहराई से गौर करना पड़ेगा।
श्री एन गोकुल कृष्णन।
Honorable Vice Chairman, sir. Thank you, sir. The government has introduced the Insolvency and Bankruptcy Code Amendment Bill 2019, wherein 8 amendments under various sections have been incorporated. Sir, the bill has proposed a time limit of 330 days for completion of the resolution process, including litigation. If it is not completed within the time frame, the bill proposes to pass an order requiring the corporate debtor to be liquidated under Class A of subsection 1 of Section 33. According to this amendment, the rulemaking power enshrined in Section 30 of the Code would be limited, as it is a matter of procedure and administration, and thus indirectly falls out of the scope and ambit of the Code. Further, the amendment specifies that those cases which are pending beyond 330 days should be disposed of within 90 days. This will be great relief to the appellants. Sir, it is clarified that The resolution plan will be binding on all stakeholders, including central and state governments and local authority to whom a debt is owed. This is created to bring an effective mechanism for dealing with the non-performing assets. The Information Utilities Regulation enacted in the IBC Code 2016 should be implemented effectively. By doing so, the information relating to the default of a registered user will be processed quickly and the status communicated to the registered users expeditiously. The amendment stresses that the operational creditors receive an amount which should not be lesser than the amount they would receive in case of liquidation. This is a welcome clause and it protects the interests of the operational creditors who now, like home buyers, became financial creditors. Sir, many experts view that the said amendments will bring confidence among the lenders. The amendment is in favor of banks since they are secured lenders and will have primacy in the resolution process.
Thank you. Nadri. No. Shri Amar Patnaik ji.
So, admittedly, this IBC is designed to bring about a paradigm change in the way business is done in India. There is no doubt that, as has been discussed, that this would improve the credit culture. This would also probably, unlock the capital. The capital which was getting locked in NPAs, it is going to unlock it and spur economic activities. And as far as NPAs are concerned, we used to have about 1 lakh crore NPA every year from 2000 to 2016, and it has decreased definitely because of this IBC. It has brought in accountability for promoters, and for the home buyers, the amendment have brought in a separate provision, which is really praiseworthy. The most significant thing is that here the responsibility for keeping the company alive is shifted from not just the promoters, the equity shareholders, to the creditors. Now, this particular act, the challenges are very important. The challenges is following the due process of law. The due process of law is enshrined in our Constitution. The due process of law has to be followed in all cases. Natural justice has to be followed. So how do you take care of this, even if you prescribe a 330 days or 270 days limit? Now that's something that the government has to grapple with. Even the central administrative tribunals, the tribunals have been set up in India basically to bring the justice system faster, make it faster. But even in the central administrative tribunals, the delay has been before. Initially the period was shorter, but after that it became delayed. There is statistics to say that in the initial period, there was a spurt in companies trying to go for the resolution process. Now it has decreased. Actually, in the last 2 years, it has decreased. The amendments, whether they can address this particular issue, is something that one has to think about. There are also concerns relating to the small operational creditors, having less than 10% of the total. What happens to them? But the most important question is, this law that we are talking about, sir, is doing the gardening work. It is cleaning up things. But you have to plant trees. For that, you have to need capacity. The capacity of the resolution advisors has to improve. The capacity of the NCLT judges has to improve. NCLAT judges has to improve. And that may actually come in the way of resolving these cases within the time frame that the amendment has brought in. Thank you so much.
After bringing this bill, workload is enormous and day-to-day cases are increasing. Between 2017 and March 2019, 1,859 companies have been admitted to the corporate insolvency resolution process. Out of that, 715 have exited the process, 370 of they liquidated, 337 withdraw or accepted the resolution plan. Around 12,000 insolvency petitions, of majority of which yet to be admitted by the National Company Law Appellate Tribunal, sir. After that, Reserve Bank of India taken a decision 1 year back. Because of that so many cases also referred to the insolvency, bankruptcy petitions. They have identified the bad loans 1.3 lakh crores by May 2019, 8,000 crores from SBI, 3,300 crores from Central Bank, 6,000 Bank of Baroda, 15,000 crores of SR Steel loans. Another banks like Andhra Bank and Dena Bank have put up their cases also for bad loan settlements. Sir, this court also having only, earlier they are having only limited benches. There are only 11 benches in National Company Law Tribunal. Apart from this case, they also look after some other cases also they have to solve. Recently, government, it seems that they have sanctioned few more benches. Might be 24 to 27 benches also they have sanctioned. But it is not sufficient in resolving the problem. This is the major hurdle being faced with resolving the cases of code, is that there is not enough number of NCLT benches which can cater of such large number of cases, thereby resulting the delay.
आप बने रहिए हमारे साथ, मिलते हैं एक छोटे से ब्रेक के बाद। जारी है इंसॉल्वेंसी एंड बैंक्रप्सी कोड संशोधन विधेयक 2019 पर संसद संवाद।
So today, the choice is between keeping a sick company as a zombie company or bringing it out of the sickness and reviving it, making it a live company, sir. So the human angle is very important here, sir. So if a company is sick, what is the condition of its employees, sir? The biggest issue employees would face or the workers would face is what is their future? Would this company survive? In this process, sir, there is a very definitive direction of keeping the company alive.
आईबीसी संशोधन विधेयक 2019 राज्यसभा में पारित कर दिया गया। संशोधन से दिवालिया प्रक्रिया शुरू करने के आवेदन के समय ही उसे पूरा करने की समय सीमा भी तय होगी। इसके साथ ही वित्तीय लेनदारों के संकट के निवारण का भी स्पष्ट प्रावधान किया गया है। वित्त मंत्री निर्मला सीतारमण ने कहा कि इन मामलों को निपटाने में केंद्र, राज्य और संबंधित प्राधिकरणों की भी जिम्मेदारी होगी।
Sri K.K. Ragesh.
Sir, as per the claim made by the Honorable Minister here, the amendment provides for time-bound resolution process. But sir, in the IBC Act itself, it has already been stipulated that after receiving a resolution application, the NCLT must determine the existence of default within 14 days. And irrespective of such a provision, sir, large number of applications are pending for admissions. And the average time that the NCLT takes is ranging from 3 to 6 months. And for many cases, it is more than a year. Sir, I think merely fixing a time frame in the law will not resolve the real problem. We have to identify the real reason. Sir, the bankruptcy law, it has got two components. One is the insolvency of corporate establishments. And the second part is the insolvency of corporate persons, including personal guarantors and promoters, etc. Insolvency dealing with corporate establishment was notified. But I want to know from the Honorable Minister whether the insolvency dealing with individuals, individual corporates is being notified, which talks under Section 60 of the Principal Act. I want to know from the Honorable Minister why one part of the act is notified and the another part, which is in fact the soul of the act, is not getting notified.
श्री मनोज झा जी।
एनपीएस के बारे में बहुत बात हुई है सर। बैंकिंग सेक्टर का अगर आरबीआई के आधार पे मैं देखूं तो 10 लाख करोड़, विच इज मच मोर देन द पेड अप कैपिटल ऑफ दीज बैंक्स। अभी और सरफेसी के बावजूद अभी हमारे सीनियर कलीग कपिल सिब्बल जी हेयर कट की बात कर रहे थे, 70%, 63%, 80%। सर ये तो पूरा का पूरा मुंडन है, हेयर कट है ही नहीं। अगर 80% बाल उड़ाए जा रहे हैं तो बचा ही क्या? ये तो कंप्लीट मुंडन है। और इसमें सबसे बड़ा नुकसान सर इन बड़ी कंपनियों का नहीं होता, बड़े ओहदेदार लोगों का नहीं होता। ये जो कंपनी के माध्यम में जो छोटे मोटे निवेशकर्ता होते हैं उनके ऊपर सबसे बड़ी मार पड़ती है सर इस मुंडन की। मंत्री जी से मैं एक और भी चीज जानना चाहूंगा कि पावर सेक्टर में आईबीसी की क्या हालत है? व्हाट इज देयर इन पावर सेक्टर? इज देयर नॉट सो अ हिडन हैंड ऑपरेटिंग इन पावर सेक्टर?
श्री टीकेएस एलन गोवन।
Chairman, sir. At the outset, I want to say that the problem of insolvency or bankruptcy is created by the governments in power. The change of policies has led to has affected most of the industries here. Sir, I don't want to mention during the change in the economic policy of the government within these last 2-3 years had affected many sectors. One example I can quote is in Chennai alone, my city Chennai alone, there are 450,000 flats constructed and could not be sold. So the problem was created by the government and the government is trying to seek resolution of the problem. That is the reason for these amendments. I don't want to go much into it, sir. I will quote one or two things from the amendment and I will ask the government to look into it. The amendment to section 31 of the IBC provides that the resolution plan that is approved under the IBC binds all governments, including the state governments. The resolution plan is approved by the committee of creditors comprising of financial institutions. Thus, power is being conferred on a private body, that is the COC of a company, to determine and undermine the interests of the states, including its revenue. This is wholly unconstitutional as the interests of the state cannot in any manner be relegated for favored private interests, including those of financial institutions. This the government should understand. The second thing is, the amendment also seeks to completely wipe out small and medium scale vendors by allowing financial creditors, operational creditors, by virtue of this amendment can be given the nil amount, while financial creditors get their principal, interest and even at times penal interest. Such an amendment is anti-poor and small and medium scale vendors who, owing to the ill practices of large corporates, would be denied their due monies for simply having been associated with them in the due course of their business. This the government has to look into.
This bill strengthens the provisions related to time limits. It sets a 330-day time limit to complete the entire corporate insolvency resolution process. This time limit would have the positive impact of making the entire corporate insolvency resolution process time-bound. This proposed amendment is welcome and indeed commendable since it ensures the insolvency process is conducted swiftly and interests of creditors and employees of the corporate body are protected. The second point that I want to make, sir, is that this 2019 amendment bill seeks to cure some of the shortcomings that existed in the 2018 Act. This bill prescribes that all the financial creditors represented by the same authorized representative would be considered as a group. An authorized representative would have to cast one vote on behalf of all financial creditors that he or she represents. This proposed amendment would have the effect of ensuring that the resolution plan is more acceptable to the committee of creditors.
Sir, it's a well-designed insolvency law should differentiate between the financially distressed firms and with that of the economically distressed firms. The two are different, sir. Sir, I would like to say that the definition of economically distressed firms is when the present value of the future expected profits of a company is less than the total value of the assets of the company, then the were the assets to be broken up and sold separately, then the company is called economically distressed firm. Sir, on the contrary, if the company is not economically distressed firm, but is merely unable to service the debts or interest, it is merely a financial distressed firm. So I request the Honorable Minister to differentiate between the two, and financially distressed firm should not be sent to the insolvency, sir. The assets of the firm are more valuable if kept together as a functioning unit. Such firm should be sustained either by restructuring or selling it to the new investor, sir. Sir, the second point, sir. Sir, we have 14 NCLTs and there are two yet to start functioning. Sir, secondly, the government has announced it's going to set up 24 bankruptcy courts. And secondly, sir, there are 27 members of NCLT against assurance of 60 judicial and technical members, sir. There are 27 judges dealing with 2,500 insolvency cases. As per the estimate, country needs about 80 more benches in the coming 5 years. I request the madam, honorable madam, to kindly look into it, sir. This last suggestion, sir. If you look at the definition clause, it deals with the definitions like debt, claim, and default. And there is a mention about the interest on loans. Sir, the Indian Banks Association wants that any default in payment of even interest should also become a case for insolvency resolution, which is deplorable and cannot be accepted, sir.
Sri Asuni Vaishno.
Sir, the IBC is one of the biggest reforms in the recent years. So one of the recent surveys done by CII and PwC, the respondents in that survey, 83% of them said that this is one of the biggest structural reforms in the recent times. What is this reform, sir? This is a very, very different picture, very different process where transparency is the biggest factor, sir. So in this process, the resolution professional, the appointment of resolution professional, the whole infrastructure of NCLT, the process which has been created, all data is kept in a purely digital form, sir. There is a data room in which everybody can access the same data. We can take our decisions based on that data, and purely the committee of creditors is taking the decision, sir. This kind of transparent system was never there, sir. And the focus on resolution, keeping a company going concern, making sure that the company survives, that is something which was not there earlier, sir. Mr. Sibal said that had the companies gone into liquidation, maybe the money which would have got recovered would have been much less, sir. So today, the choice is between keeping a sick company as a zombie company or bringing it out of the sickness and reviving it, making it a live company, sir. So the human angle is very important here, sir. So if a company is sick, what is the condition of its employees, sir? The biggest issue employees would face or the workers would face is what is their future? Would this company survive? In this process, sir, there is a very definitive direction of keeping the company alive. So that is why we should all support this process. We should all strengthen this process, sir. The biggest change which has come in is the behavioral change, sir. So there was a time when the promoters, the entrepreneurs would not even consider what is the debt they have on their books, sir. Today, I know many entrepreneurs who are personally monitoring their debt levels on a day-to-day basis. Daily, something should reduce from that level of debt, sir. That is what people are thinking, sir. That's a great behavioral change. Not only the entrepreneurs, sir, the banks are also following up, sir. Earlier, contracts would just be signed just like that, and nobody would bother, sir. Sir, there are going to be long-term implications of this code and this system and this structural reform, sir. this will definitely differentiate between good entrepreneurs and bad entrepreneurs, or let me put it like genuine entrepreneurs and bad entrepreneurs. It is definitely going to bring in stability, which is the key to investment, which is the key to employee welfare. This will also lead to keeping the bank's balance sheets healthy, sir.
राज्यसभा में पारित होने के बाद आईबीसी संशोधन विधेयक 2019 लोकसभा में भी पारित हो चुका है। वित्त मंत्री निर्मला सीतारमण ने कहा कि विधेयक का उद्देश्य समाधान की प्रक्रिया को तय समय पर पूरा करने के साथ अधिकारों के बारे में और स्पष्टता उपलब्ध कराना है। वहीं समाधान के तहत हमारा मकसद मर्जर, पुनर्विलय आदि की प्रक्रिया में पारदर्शिता लाना है। फिलहाल इस अंक में इतना ही। अगले अंक में इस विधेयक से जुड़ी बाकी चर्चा और वित्त मंत्री निर्मला सीतारमण के जवाब के साथ हम फिर हाजिर होंगे। तब तक के लिए दीजिए इजाजत। नमस्कार।
सभापति महोदय, बैंक एक बिल्डिंग नहीं है। अगर एनपीए बने हैं तो बैंक में भी बहुत सारे लोग थे, इसमें इन्वॉल्व थे। कॉर्पोरेट में ऐसा सब चोर नहीं है, सब जानबूझ के विलफुल डिफॉल्टर नहीं है। ऐसे बहुत सारे सेक्टर्स हैं, बनते गए डिफॉल्टर, बनते गए धीरे धीरे। तो इन लोगों के लिए प्रोविजन है इस बिल पे, अमेंडमेंट में, कि ताकि वो एक बार उठ खड़ा हो जाए। सब किस्म की उपाय दिया जा रहा है और टाइम बाउंड होने से एक फ़ायदा होता है कि सबको जवाबदारी देनी पड़ेगी।